Court will now call case number 127505, State of Kansas versus Jaron Chance Palmer.
Madam Chief Justice, may it please the court. Sean Randall of the Appellate Defender's Office on behalf of Jaron Palmer. Your Honor, I request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. As your honors are aware, I've raised 2 issues on behalf of Mr. Palmer. One is whether or not the ultimate killing of Mr. Stokes occurred while the attempted robbery was taking place. And the other issue is an instructional error, which I believe the state has conceded was an inappropriate instruction. So the question would be just reversibility as to what's before this court. As to the first argument, I think what this court has to begin with considering is when the attempted robbery in this place concluded and when that was done. This court's defined robbery as completed when the taking of the property is done. And an attempt would be obviously any overt action towards the commission of that offense. And so my argument would be that the attempted robbery in this place was done whenever Mr. Palmer and his accomplices stopped taking any overt actions to take the property from the apartment residence. What you have in this case, I believe, would be that the testimony was that either Mr. Palmer's brother or the other accomplice that he was with went towards the back of the residence while Mr. Palmer stayed in the living room. There was some banging on the bedroom door in which 3 of the apartment residents were in, and they had locked the door. And there was then a shot that was eventually fired from one of the apartment residents through the door. It did not hit anybody, and at that time they all left and fled the residence. It was only then at that point that Mr. Palmer or his brother or someone, one of the accomplices, fired the shots into the apartment, one eventually striking Mr. Stokes and resulting in his death. So my argument is that at the time that the shooting and the firing took place, the attempted robbery had been concluded. They were no longer.
Where have we ever said that in the context of a felony murder?
Well, Your Honor, what you've indicated.
Really trying to pinpoint something that I don't think we've said before, right?
Well, of course, Your Honor. I would admit that there are plenty of decisions that indicate that this court has never indicated that it has to occur during the commission or during the attempt. But I think what we have here is a very distinct situation. And when we look at the felony murder statute, I think there's only 3 ways that someone can be guilty of that. There's a killing that occurs either during the commission of an inherently dangerous felony, during the attempted commission of an inherently dangerous felony, or flight from an inherently dangerous felony. He was not charged for killing someone during the flight from an inherently dangerous felony, and I would argue that attempted aggravated robbery is not an inherently dangerous felony. And so I don't think if the legislature has specifically said, look, flight from an inherently dangerous felony, that means flight from an aggravated robbery, but it does not mean flight from an attempted aggravated robbery. And so if we have the legislature delineating that, I don't think we can try and now use res gestae or some other mechanism to say, well, the fleeing was taking place, but that's part of the attempt. And so we're trying to backdoor it in, or I think that's how I would argue it. You've got an attempted robbery that they terminate, they stop trying to take any property, they stop trying, they don't make any demands. There's no allegations that as they're running away, they're saying, still give me property, or that they're attempting to take any property. They're done. They've stopped. They're fleeing. They're running. But that's not how it was charged by the state. That's not what the statute allows. And I don't think that we can now try and say, well, we're using fleeing, but not under the statute, but under res gestae as part of the attempt. And so I think when you've got a cessation of any overt acts towards trying to take any property, you've got the cessation of the attempted robbery, and so that the shooting did not take place during the attempted robbery. I think that also kind of leads into whether or not there's, obviously, I don't believe that res gestae, specifically the fleeing or the running away or the shots that were fired at that time. I don't believe that, again, res gestae, saves that. But if this court were to find that, I've also argued and would continue to argue that the shot that was fired by the apartment resident would be an extraordinary or intervening circumstance that broke the causal chain between the attempted robbery and the ultimate killing of Mr. Stokes. I understand kind of the reaction against that. I know there's this longstanding case law that talks about when you commit a robbery, you're a potential assassin, and here's all the reasons why, because these things. And I think when you look at that language and you look at the reasons why that are submitted by the court, you can really kind of lay those factors out or those reasons for four things. I mean, it says either to defend yourself, to defend a friend or a loved one, to actually use the gun in the effectuation of the crime, or to evade pursuit or capture or something along those lines. I don't think we have here, and it says that those are the four reasons why attempted robbery and why a person who engages in attempted robbery, that death or harm or violence is foreseeable. It says it because all of those four things are easily foreseeable. But in this case, I don't think we have any of those four things to support the foreseeability. The gentleman who fired the shot did not know whether or not the person on the other side of the door was armed, did not know whether or not a robbery, I think, was taking place. I mean, he had been told by his girlfriend, hey, there's these three guys here, maybe, don't know what's going on. But he's not, I believe, defending himself or defending a loved one. Mr. Palmer certainly never used the gun, I think, to effectuate the robbery. And there's no testimony that anybody chased or gave pursuit or anything to that effect to indicate that he used the gun to effectuate that escape.
It was effectively a home invasion, right?
I mean, effectively, yeah, I would agree with that.
I mean, I guess I don't understand why that's not foreseeable that an occupant of the home that is being invaded would take force against the perpetrators.
Because I think as I've read the case law regarding that foreseeability, Your Honor, it seems to be that it's foreseeable because someone will attempt to defend themselves or a loved one. And so just the fact that your home has been invaded, I'm not going to sit here and try and mince as to whether or not that does or does not. I suppose I shouldn't, but I don't believe he was acting in the defense of himself or another. I don't.
You're just
he did not. I'm sorry, Your Honor.
Oh no, I didn't. I interrupted you, but it sounds like you're suggesting you're just trying to tie it factually to the rationales that have historically been given in those decisions.
That's correct.
Okay.
That is correct, Your Honor. And the reason why we bring up foreseeability is because that's how this court has traditionally defined extraordinary, as meaning it's something that's unforeseeable. And so if the facts in these circumstances don't line up with the foreseeable uses, I would argue then that it's unforeseeable and thus extraordinary. I don't want to prevent or take too much time focusing on this issue without having the opportunity to discuss the second issue, which is the instructional error. I believe the state has conceded that it was an inappropriate instruction and that it was given in error. But there is some disagreement between the parties as to whether it was preserved properly or how it was raised below. I think if I were to understand the state's argument, it seems to claim that any objection that was raised by Mr. Palmer below during the instruction conference was an objection on factual appropriateness, and that the argument now raised here to the court is the legal appropriateness of the instruction. I would disagree with that contention. I believe he said we don't believe the evidence supports the giving of this instruction, and I believe the way that can be viewed as both a legal and factual appropriateness objection, Your Honors, would be that if the burden of proof has been impermissibly lowered by the state, then then the argument about the evidence not meeting that would be that perhaps if the appropriate burden was given, then legally this would not be, that this instruction would not be appropriate. But I think we're wading perhaps into the weeds, because I think regardless of whether this issue was preserved or not, and if this court were to find that it was not preserved, I think we still meet the clearly erroneous standard. What we've got is competing jury instructions with multiple mens rea definitions. You've got one that defines intent, and you've got another one that defines or equates it with foreseeability. And I think that when you're having multiple jury instructions that give conflicting definitions, especially when they're relating back to robbery, which was related back to attempt, which was related back to the felony murder, when they're all read together, that we have a substantial likelihood of confusing of a confused jury when trying to determine exactly what intent was or was not required. And I think if they had been appropriately instructed, I believe that the verdict and the outcome of this case would have been different. I know that we have testimony from one person, which was the accomplice who was certainly part of this and certainly went to the back of the bedroom, and who ended up getting a deal for 5 years, who indicated that the plan took form in the car ride over to the apartment. And that's what you've got as far as, this alleged intent to engage in it. But I think when you look at the other evidence that was submitted by the people, because the residents of the apartment, my client didn't testify, so these are all things that were said from the other residents in the apartment. But I mean, you've got, I think the evidence established that either my client's brother or the other accomplice were the ones who went towards the back of the residence. You've got the testimony that I believe my brother's client was the one who likely pushed open the door. You've got the only other resident who was in the living room where Mr. Palmer was allegedly standing, who testified that he wasn't even sure that a robbery was necessarily taking place. You've got a lot of things, I believe, that this court can look at to determine whether or not there was intent that the jury could have taken into account if the burden had been appropriately set where intent was, rather than just this general language regarding foreseeability.
Even though the intruders wore masks and your client had a gun,
there is
no intent to. I don't track your argument about there not being enough evidence that the jury could decide against you.
I'm not. I guess I'm not disagreeing that there isn't some evidence. I'm disagreeing with that if the jury had taken that evidence also into account with the other evidence, that I think they could have reached a different verdict, Your Honor. As you specifically mentioned the fact that they were wearing masks. I believe this occurred during the COVID timeframe, and I believe it was discussed on the record that it wasn't necessarily uncommon for people to be wearing masks, you know, when COVID were taking place. There was no discussion that this was a ski mask, you know, or any testimony of that. The only testimony about a firearm, I believe, was there was one of the apartment residents who kind of stuck her head out of the bedroom and saw what was going on, and she described that she had seen a firearm in my client's brother's possession. And I don't believe there was any testimony, and I'm sure the state will correct me if I'm wrong, that my client was necessarily waving the gun around or pointing it or shooting it or threatening anybody with it. And so when the court is pointing out the fact that there was masks and they had a gun, that clearly they must have had the intent. I think there's other circumstances that the court and the jury, you know, could consider that would have led to a different result. So I obviously have exceeded my time, but will stand for any further questions that the court may have at this time. Thank you, Your Honor.
Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. In April of 2021, the defendant and Brecken Elliott picked up the defendant's brother Easton, and they headed out under the initial auspices of going to buy some marijuana. But along the way, a plan developed that they were going to rob THC vape cartridges from an apartment in Wichita. Two of the individuals involved, Brecken and Easton, knew people that lived in this apartment where they ultimately went. On their way, they masked up, they armed with guns, they essentially shove the door down, knocking one of the individuals inside to the ground. That individual is able to hide behind a couch. There's unfortunately another individual there. His name is Eric Stokes. He ends up stuck in or near a chair there in the living room. As the plan continues along its progression, Easton and Brecken head towards their back portions of the apartment, Easton to an empty bedroom, Brecken to the door, where inside three individuals, one of whom had seen the armed robbers come in and told her boyfriend and his friend about it. So the men in that room armed themselves. As the door is being beaten down and starting to give way, one of the individuals in that bedroom fired a single round through the door. It hit no one. At that point, Easton fled past the defendant and Brecken, and in that flight, the defendant doesn't flee. At that point in time, he does not flee. The defendant fires 8 shots in the apartment or near the apartment entry. The defendant is ultimately the last to leave. The defendant was so effective in his shooting that one shot traveled through the living room, through a wall, and hit one of the gentlemen in the bedroom in the leg. It was a very tight pattern, both in where the casings were found and where the aim had been. They flee. The defendant disposes of some of the attempts to dispose of some of the evidence. What we have before us today, and this court has to evaluate, is whether or not the evidence was sufficient to determine that the killing here of the Mr. Eric Stokes, who was stuck in the chair and hit and killed when the defendant started shooting, was that during the res gestae of the underlying felony, here and that being aggravated robbery. The problem that the defendant runs into here, and the entirety of their brief and argument today, is that all they're arguing is for an interpretation of the evidence. And it is an interpretation of the evidence that is contrary to how this court views the evidence in appeals like this, which is this court must review the evidence in the light most favorable to the state, including any reasonably drawn conclusions or inferences that can flow from that evidence. Here, the state has made no secret of the fact that for one reason or another, the charge was narrowed, and in that originally the felony murder included the full res gestae element, but come time for the jury instructions, that element was narrowed to only include the attempt language. Ultimately, at the end of the day, the defendant is simply pressing for, as I mentioned, an interpretation of the evidence. Any reasonable interpretation of the evidence, especially interpretation of the evidence in the light most favorable to the state. The evidence of a murder here was overwhelming.
Counsel, let me focus you on what I'm getting the impression is a popular argument by the appellate defender's office on this, trying to pinpoint a moment in time when the underlying crime was completed, and so anything that happens after that falls into it. Now, I can see where your interpretation of the evidence argument plays in against that. Are there other things that play against that argument? See what I'm asking?
I believe that I do, and obviously, I understand you're telling me that you see that our position about the standard of review cuts heavily here, and I think
I'm just saying that when I'm doing columns here,
Yeah.
that's one that I understand you're putting on. I'm just trying to figure out if anything else goes into your column on trying to argue against this notion that with felony murder, we get to look and pinpoint a time when the underlying crime was completed and we're done,
and I think
especially on an attempt.
my best answer, Justice Biles, I think, is that it would become circular, because the question of whether or not the underlying crime is quote unquote completed is a question of fact. And that fact on review must always be reviewed in light most favorable to the state. So it cannot lead defendant anywhere. It is a meritless legal argument in that respect.
Maybe let me ask, I may be asking us the same question as Justice Biles, but under the felony murder statute, the focus is on, a killing during an inherently dangerous felony. Here, it was robbery, not attempted robbery, but robbery. And so I understand your position to be that you probably charged the entire res gest. I don't recall, but for some reason it was narrowed. But that the state's not forced. These are not like alternative means, attempt, flight, commission. It's really a temporal period, and if it falls within that period, that's a felony murder.
That is absolutely correct, Your Honor. And you are also correct. The state initially charged the full res gestae element as you've described, and the statute is during the attempt, commission, or flight from an inherently dangerous felony. And again, I think it was narrowed here. I can't necessarily say why. It's a practice that I hope ends.
And then do we measure the sufficiency against the statute or against the instruction?
The way that I've briefed it, and frankly, because the instruction is what the verdict had to be based on here, is that you weigh it against the instruction. And I think that even doing so here, there is no question that the killing here occurred during the ongoing attempt at aggravated robbery. I would briefly note is in regards to the extraordinary intervening event not existing, as I noted in my brief, and again, math isn't always my strong suit, but as I counted it, it's been nearly 100 years or more at this point, where it's been settled law in Kansas that anybody that is committing a robbery, especially one that's armed, is a potential assassin, because they know they may be forced to use that weapon to carry out their criminal act or escape without being pursued or captured. The one thing that I wanted to note in addition to that, as was presented today, it was Justice Wall, you were asking about the fact that this was a home invasion. If anything, the status of the law in Kansas at this point in our stand your ground and our firearms laws and legislation as it stands now, this is extra foreseeable. If you're going to kick down somebody's door and try to commit an armed robbery at a home, it is extra foreseeable that that's where people keep guns. I mean, there's just no question. If there are no other questions on the first issue from the brief, I will briefly touch on instructional error. As the appellant notes this today, the state does concede there was an instructional error here. However, this is not the same result is not dictated as what occurred in Mora. The first thing, as the state points out, I think that the record is fairly obvious that this court must review this instruction for clear error, which is initially different from Mora right off the bat. The state's point in its brief regarding preservation below is the state cannot say that there was at any point a clear objection to this instruction or the language that was used here at all. And second, whatever the objection was when it was made, it was purely factual, not legal in nature. So even if we could stretch any of the objections that were made below to somehow apply to this, it cannot be stretched into the factual realm that the defendant argues on appeal. Then, and the reason that matters is the burden's different. Here, the defendant's burden is he has to demonstrate he has to show that that this instruction was clearly erroneous versus and that a jury would have reached a different verdict as opposed to just showing that there's a reasonable probability. And the defendant cannot do that on the record of this case, as I've set forth in my brief. I guess briefly, the one other question is Justice Biles, I think that you had on that regarding an intent and a plan. The state's evidence here was a little more clear. I mean, this was a plan that was discussed in the car on the way over. They do put on masks. COVID times are not walking outside up to an apartment door that no one's expecting you in. Clearly suspicious. They're all armed. They're seen armed. They stash the car and then try to get away. This was planned from beginning to end. And the defendant here was the ringleader. So simply put, nothing that the defendant argues could firmly convince this court that the jury would have reached a different verdict, because all that he's arguing, again, is for a different interpretation of the evidence. And frankly, it is one that the state believes is not reasonable. If there are no further questions, Your Honors, I appreciate your time this morning. And I would ask that this conviction and sentence be upheld. Thank you.
Thank you, Mr. Gillette. Mr. Randall, you reserve 3 minutes.
I only wanted to address maybe a couple things that were hit on during my colleague's argument. There was the assertion that my client was the ringleader of this situation, but I would note that my client is the only one who does not know who lives at this residence or what is taking place at this residence. We had indications that both Brecken and Easton were familiar, had been over to the residence, knew who was there. There was no testimony that anybody had ever met or knew of my client. I would also note that neither here nor there, because I think what I really want to highlight on, and I think what the majority of you have been wrestling with is this idea that myself and perhaps other members of my office are trying to argue that there is a terminus or a conclusion at which point the underlying felony has stopped and taken place, and that any killing that occurs after that takes place would not satisfy the requirements of the felony murder statute. But and I heard my colleague mention, and I think some of your honors have mentioned this idea of res gestae, and I want to go back to that, because res gestae is a court-made doctrine. And obviously this court is allowed to do that and allowed to interpret things to give effect, but it can't do so when it contradicts clear legislative directory as written in the statute. And the legislature has made it clear in this context that if you're going to allege that a person is killed during the flight from an inherently dangerous felony, it must be from an inherently dangerous felony, which is defined as aggravated robbery.
Does the statute use the word during?
It does not. It says
That's your argument is you've said that multiple times, that it's during, but the statute just says in, right?
It says in the commission of, I believe, Your Honor, in the commission of, in the attempted commission of. or
And
the
isn't there a
flight.
difference between during, I mean, I understand why you use that word because it arguably creates a tighter temporal zone. But the statute doesn't have that word in it.
No, it says as relevant to the case before the court, it would be in the attempted commission of.
Why isn't in temporally broader than during?
I'm not going to disagree. I suppose that it is perhaps temporally broader, Your Honor. And I believe there's case law here that notes the statute does not say the word during. I think I even perhaps put that in my brief, when I was originally citing it. My contention, though, is not necessarily about the temporal. My contention is that I think the legislature has specified that if we're going to allege that someone was killed during the flight, it must be based on an inherently dangerous felony. And as I've mentioned, I believe multiple times, aggravated or attempted aggravated robbery is not an inherently dangerous felony. And so to try and say, well, the statute says this, but we've identified res gestae as all encompassing in this greater temporal time frame. I believe that contradicts the clear intent and language of the legislature in the felony murder statute.
You said that if you're going to allege, a killing during an attempt, but is the state required to even do that? I mean, I know it happened here, but more broadly, in looking at the statute more generally, the state could allege that entire temporal period contemplated in the felony murder statute, don't you think?
I understand based on your questions that you had posed that this court doesn't view commission or attempt or flight as alternative means, and so if that's the operation, then I would have to submit that it could be. But,
Okay, yeah,
but
I'm not trying to answer that question today, but I understand. Yeah, if it were, that's a separate issue. But setting that aside, I mean, just based on the statutory text, yeah, it appears that it covers a more broad, expansive temporal period.
And perhaps it does, Your Honor, but I think as you noted, and the issue that's before this court is that it was narrowed
Sure.
specifically to committed during the attempted aggravated robbery. See no further questions? Thank you very much for your time, Your Honors. I appreciate it.
Thank you. Thank you to both of you for your arguments today. Court will take this case under advisement.